Cheques are a crucial part of business transactions, but what happens when a check issuer deliberately stops a payment? Can they escape legal consequences? Today we break down Cements Ltd, Kuchil Kumar Nandi, 1998, a landmark case that clarified whether a stop payment order protects the drawer from legal action under Section 138 of 1881. Our story begins in Kolkata, India, where Kuchil Kumar Nandi, a contractor, purchased cement worth 6 lakh rupees from Cements Ltd on credit. To settle the dues, Nandi issued 3 post-dated checks in favor of Cements Ltd. However, before the checks could be deposited, Nandi instructed his bank to stop the payment. When Modi Cements presented the checks, they were dishonored with the remark, "Payment stopped by drawer." This raised a critical legal question. Does stopping a check payment protect the drawer from liability under Section 138 of the Negotiable Instruments Act? To answer this, let's examine the Negotiable Instruments Act, 1881. Section 138 of the Act states, if a check is dishonored due to insufficient funds or exceeding the arrangement, the drawer is liable for prosecution. But here's the twist. Nandi's lawyer argued that the check wasn't dishonored due to insufficient funds, but because of a stop payment instruction, meaning Section 138 shouldn't apply. The case went to the Supreme Court of India, where both parties presented their arguments. Nandi's lawyer confidently making his case. Nandi's lawyer, Your Honor, my client stopped payment because of a quality dispute over the cement. Since the check wasn't bounced due to insufficient funds, Section 138 should not apply. Modi Cements Ltd's lawyer, Your Honor, once a check is issued, it is legally considered a promise to pay. Stopping payment is a deliberate attempt to evade liability. The Supreme Court had to decide, does a stop payment instruction exempt someone from prosecution under Section 138? The Supreme Court ruled that a check is a financial commitment. Once issued, it is legally binding. Stopping payment does not erase liability. It still falls under Section 138. The burden of proof is on the drawer to show a valid reason in court for stopping payment. Judge, verdict. The drawer of the check cannot escape liability under Section 138 simply by issuing a stop payment order. The accused is held responsible for check dishonor. So, what's the key takeaway? Lesson number 1. A stop payment order does not protect you from check dishonor liability. Lesson number 2. Once a check is issued, it is legally a commitment to pay. Lesson number 3. If a check bounces, the drawer must prove a valid reason in court. Lesson number 4. Always ensure sufficient funds before issuing a check to avoid legal trouble. The Supreme Court's ruling reinforced that checks must be honored and stopping payment does not erase legal responsibility.